You're watching News 54. Court of Appeal Judge Fatuma has ruled that there was no evidence that the head of state President Uhuru Kenyatta was served with notices of court. According to her, the High Court was never showed any evidence that President Uhuru Kenyatta was served. She stated that the petitioner did not provide any evidence to show that President Uhuru Kenyatta was served. This is against the principles of justice on His Excellency the head of state President Uhuru Kenyatta. She has since argued that it was alleged that President Uhuru Kenyatta was sent the email through his official and not private email, yet he was being sued as a private citizen. The judge has ruled that the High Court erred by going ahead to hear the petition, yet they did not ascertain whether President Uhuru Kenyatta had been served. Justice Fatuma has also ruled that the issue of verification of signatures is not a matter requiring a policy decision. It is not a matter that arises out of resolution or decisions made by the commissioners, but one dictated by the operation of the law. It does not require the 𝗦𝗊𝗐𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏𝗏
challenging the High Court's finding on the applicability of the doctrine of the basic structure in Kenya. On the other hand, the respondents opposed to the appeal came out in equal measure in support of the findings of the High Court. Both sides of the divide relied on scholarly writings, decided cases in Kenya and elsewhere, as well as the history, text, and context of the 2010 Constitution. It is noteworthy to point out that the scholars themselves were not in agreement on the applicability of the doctrine. Professor 𝗦𝗫𝗍𝗔 𝗂𝗃 and Professor Charles Manga Fombard supported the notion of non-applicability of the basic structure doctrine in Kenya, whilst Dr. Ojwang, Dr. Linda Musumba, and Dr. Osogo supported the notion of the applicability of the basic structure doctrine. Be that as it may, the respondents opposing the appeal expressed fear that if the legislator is left unchecked, the 2010 Constitution may be dismembered and mutilated to the extent of it being a shell of a constitution. No doubt, the respondents' deep-rooted fear is informed by the history of lack of constitutionalism in Kenya. It is for this reason that the respondents opposed to the appeal urged us to find that the basic structure doctrine is rooted in Kenya's history, text, and experience, as well as comparative constitutional theory in the form of decided cases and scholarly works. It was their argument that the courts must reconcile contradictions, draftsmanship gaps, vagueness, and phraseology in the Constitution and arrive at the conclusion that the basic structure doctrine is applicable in Kenya for the safety of the 2010 Constitution. In support of their contention, they relied on several authorities which I have set out in my judgment, and in the interest of time, I shall not go through all of them. But the ones that I brought on board into my judgment include in the matter of the Speaker of the Senate and another, 𝗪𝗲𝗃𝗏𝗄𝗏 versus University of Nairobi, in the Commission for the Implementation of the Constitution versus the National Assembly, where 𝗓𝗏𝗄𝗏 J, as he then was, held that where the basic structure or design and architecture of our Constitution are under threat, the court can genuinely intervene and protect the Constitution, end of quote. They also relied on the decision of 𝗔𝗕𝗢𝗪, and as I've said, they also relied on scholarly works, in particular the works of Professor 𝗧𝗏𝗃𝗏𝗏 writing on implied limitations. In support of the contention that the Constitution also has the unspoken language, they placed reliance on scholarly writings of 𝗬𝗎𝗔𝗔 in unconstitutional constitutional amendments, the limits of amendment powers, where he states, and I quote, "In order to find an amendable basic principles, one has to resort to interpretation of the Constitution as a coherent whole. It is, after all, a constitution and not just a disjointed collection of constitutional pieces which must be interpreted. According to this approach, the language of the Constitution is not merely the explicit one, but also the implicit one. The respondents opposed to the appeal argued that notwithstanding the fact that the 2010 Constitution does not expressly bar amendments, it does so implicitly, as one has to pay attention to its overarching themes and/or the spirit of the Constitution. Heavy reliance was also placed on the Indian Supreme Court decision of 𝗕𝗲𝗓𝗪𝗓, and in this 𝗕𝗲𝗓𝗪 decision, by a majority of 7-6, it was held that there are some provision in the Indian Constitution that form the basic structure of a constitution and hence are not amendable, not even when the prescribed procedures are adhered to. On the other hand, the appellants and the respondents in support of the appeal were clear. The basic structure doctrine is not applicable in Kenya. They urged us to find that the 2010 Constitution has sufficient safeguards that militate against hyper-amendments of yesteryears. The appellants and the respondents supporting the appeal also sought to rely on case law, decided cases, the history, text, and context of the 2010 Constitution. These included in the Council of Governors versus the Attorney General, where the Supreme Court stated as follows: courts may not impose a meaning that the text is not reasonably capable of bearing. In other words, interpretation should not be unduly strained. It should avoid excessive peering at the language to be interpreted, end of quote. On the invocation of the spirit of the Constitution, reliance was placed on a decision of South Africa in the decision of the Premier of KwaZulu-Natal versus the President of South Africa, where the Constitutional Court held that, and I quote, "The reliance upon the spirit of the Constitution is, in my view, misconceived. There is a procedure which is prescribed for amendments to the Constitution, and this procedure has to be followed. If that is properly done, the amendment is constitutionally unassailable," end of quote. Back home, the appellants and the respondents in support of the appeal also relied on the decision of 𝗔𝗕𝗢𝗨𝗧. They also cited the decision of the Speaker of the Senate and another, and also the decision of the Attorney General and another versus 𝗓𝗏𝗏𝗏, wherein these courts acknowledged that the people may amend the 2010 Constitution by a referendum to alter the territory of Kenya. That is to give effect to secession. They also cited the decision of the Senate and 48 others versus the Council of County Governors and 54 others. Then there is also the decision of Titus Alila and 2 others, where Fred Ochieng Judge acknowledged the fact that our Constitution does indeed make provision for the amendment of the Constitution. In my view, the above decisions underscore the fact that the 2010 Constitution is amendable, subject to the process and methodology of amendment set out in Articles 255 to 257 of the Constitution being adhered to. As regards jurisprudence from foreign lands, decisions from Malaysia, from Singapore, there were also decisions from Uganda, from Zambia and Tanzania, wherein the appellants and the respondents who were in support of the appeal relied on, and all these decisions rejected the notion of the basic structure doctrine. In particular, I wish to read